Good evening. This is John Milburn for Laws 13010, which is evidence and proof. We're into week 5. And this week we are dealing with oral evidence. It's chapter 6 in our text. We've already talked about oral evidence in each of the weeks so far to some degree. And we've talked about oral evidence in the context of how it's used in court proceedings. We know that there is examination in chief, we know there's cross-examination, and we know about re-examination. I expect that everybody knows how they're used and who are the people involved in that process. If not, please ask. What we haven't done is specifically distinguish between the way in which trials are conducted in the District and Supreme Court as opposed to the way in which they're conducted as hearings in the Magistrates' Court. Well, they're basically the same, but there's an obvious difference between criminal law trials in the District and Supreme Court and the Magistrates' Court. Anyone wish to offer an opinion as to why they're different?
The jury.
Spot on. Thank you, Diana. The jury. So in the District and Supreme, typically, not always, but typically we'll have a jury for criminal law trials. We won't in some circumstances, for example, where there's a degree of complexity, but mostly where there's a child involved, they get an election. But leaving that aside, the basic procedure of a trial is the same in the superior courts as it is in the Magistrates' Court. Sometimes a trial can be dealt with in the absence of an accused, but that's only rarely invoked, and that's in the Magistrates' Court. Have a look at section 142 of the Justices Act in that regard, which talks about simple offences being dealt with in the absence of the accused person. Okay, so in evidence in chief, we're calling someone to give evidence, and we lead them through that process by examination in chief. What we can do in very limited circumstances is use closed questions, and what we can do in even more limited circumstances is use leading questions. Leading questions when you're examination in chief are really limited to those basic issues, that you can say, your name is John Smith, you live at this address, you are an engineer, you gave a statement to police about the incident, and then that's pretty much the extent of leading questions. Then you can go on and ask the open questions. And we know that when you're asking open questions, or some leading questions, or some closed questions, but what you tend to do in examination in chief is break it down. We know that. And so you try to have I call it a concertina effect or a domino effect, where you're layering one question on top of another and not incorporating more than one concept into a single question. All right, so leading questions. Can you give me a couple of examples of a leading question, one that would be prohibited? No examples of a leading question. All right. We know that the leading questions can be of two types. So a leading question is one where there is a presupposing of information built into the question. You were driving a red car when you committed the burglary, weren't you? It's really two things there: the red car and the commission of the offence. So you've got to break that down, one after the other. Establish whether it was a car, establish whether someone was driving, then you go on to establish the colour. Having done that, you then go on to talk about or ask questions about how the driving or the use of that car was relevant in that case. So we call that domino type questioning. And the other type of leading question is where you're essentially giving the person the answer and asking them to agree or to disagree, as the case may be. Now, that's in examination in chief. In cross-examination, we know that leading questions are fine, and that's very common, and it's appropriate to do that. But in your reading, you would have read about some other exceptions to the rule against leading questions. Have a look at R.V. Shaw. It's 1996, won Queensland Reports at 641. And that case is authority for the proposition that it's perfectly acceptable for a Crown for a Crown counsel to ask a victim in a rape trial, did you agree to have intercourse with the accused? It's a leading direct question, but it's not banned because it goes to the very heart of the case. The Crown has to prove that there was no consent in those circumstances, so it's perfectly permissible in that situation to ask the question. At common law, there is a general ban on a witness being asked questions about previous consistent statements made by them. In other words, a witness can't introduce evidence of what they said earlier in order to support the veracity of what they're saying now in the witness box. Does that make sense? So if a witness makes a certain statement about what they saw, what they heard, what they smelt, what they touched, then that's fine. But what they can't do is try to bolster the weight that might be given to that evidence by saying, oh, and I've said that 100 times before. We don't care that you've said that 100 times before, normally. What we want to know is what you are telling us now. So there is that general rule against a witness giving evidence about previous consistent statements made by them. And the reason for that is it's irrelevant and it's technically hearsay. But there are some exceptions to that rule. So I know we've only got a small class again, but thank you for joining us. But can you think of any exceptions to that rule about a witness being asked about previous consistent statements made by them? Note takers on that one? All right. Let's think about a case involving an allegation of sexual offence, rape, for example, and the issue of fresh complaints. So at common law, there was an exception where evidence of a fresh complaint of the sexual assault, perhaps the rape, was admissible. And also there's an exception about evidence that this goes against allegations that the witness is now giving evidence of a recent invention. Now, you would have read about the material about evidence of fresh complaint in your material. Be aware that the common law is now altered by statute, and it's important that you read and consider Section 4A of the Criminal Law Sexual Offences Act of 1978. You see, the whole issue about fresh complaint and the admissibility of fresh complaint or lack of fresh complaint really comes down to credit, doesn't it? It comes down to the credit of the complainant. This is the argument anyway. So the argument was, before the introduction of the legislation, look, if the complainant didn't make a complaint at this time and made the complaint later, so therefore it wasn't a fresh complaint, that probably is evidence that goes to the credit of what they're trying to tell you now. In other words, did it actually occur in those circumstances? Fortunately, the law has changed, and the Section 4A now says, and it's very clear, that evidence of a preliminary complaint, we don't call it fresh complaint now, it's a preliminary complaint, made by the complainant about the alleged commission of an offence by the defendant is admissible in evidence and it doesn't matter when that preliminary complaint was made. So we don't call it fresh complaint, we call it now preliminary complaint. So the common law has changed in that regard. And it's important that the judge directs the jury appropriately in those circumstances. In other words, this is the rule in terms of preliminary complaint. The judge is not allowed to warn or suggest in any way to the jury that the law regard the complainant's evidence to be more reliable or less reliable because of the length of time before the complaint was made. Provided it's a preliminary complaint, it's admissible in that regard. And we do that in the interests of justice. And we know now, of course, we're much more enlightened now to know that people don't necessarily make an immediate complaint in relation to sexual assault. And the complainant shouldn't suffer a detriment in those circumstances simply because of a delay. Now, given that we don't use that term fresh complaint, we now use the term preliminary complaint, I guess it begs the question, what is a preliminary complaint? Well, what we can say is that it's a complaint made before the trial or investigations into the trial about a certain matter. So if, for example, a person makes a complaint to a school teacher or a guidance officer about something that may have happened at home a couple of years ago, that's a preliminary complaint. If they go to the front counter of the police station and they make a complaint, then that's a preliminary complaint. But if they actually make an appointment and they give a formal statement to the police officer, that's not what we call a preliminary complaint anymore. That's part of the direct evidence in the case. And of course, the evidence that that person, the complainant, may give in the witness box is not a preliminary complaint. It's evidence of what's happened. So what do we take from section 4A? The important thing is that you're aware of 4A, you read 4A, and you understand that a judge may not make any adverse comment to the jury about the complainant being less reliable because typically she did not make that complaint at an early time. What you can do to get a very clear idea of the law on this topic is have a look at the bench books. I think I mentioned the bench books before. The bench books provide practical guidance in relation to matters involving directions by a judge to a jury in relation to certain matters. And you'll find these bench books in the Supreme and District Court. They're available on the court's website, and I'm just going to direct you to that page. So I'll share the screen now. I may have shown you this before. Bear with me if I have. You should be able to see my screen, my cursor, and the bench books. If you look to bench book number 64 from memory, you'll see that there is a statement here about preliminary complaint. Let's go into that. And you'll see that that's, if you like, for want of a better term, a script that could be used by a court to a jury in relation to issues to do with preliminary complaint. If you read that, you'll have a very clear understanding of what the court is intending to convey to the jury. You'll see that there is reference there specifically to section 4A. There's also some case law. So that's a great resource that's available to you. And I'd urge you to look at the bench books, not just bench book 64, but bench books generally, because they do provide you with a great opportunity for a valuable resource. All right. Now, it's not on Moodle, but the bench books you'll find in the court's website. And even if you just Google bench books, you should be able to find it pretty easily. There's a whole lot of them, so they're a great resource. The one that comes after 64 is 65. It's about a Longman direction, and that talks about a delay between the incident and the complaint. So in a way, the Longman direction works a little bit against the section 4A, but there is a reason for it. So we're not saying that because of a delay, that in itself means that the evidence is less probative, but basically says you can't treat the evidence as being less valuable because it wasn't made immediately. That is complaint evidence. But there is the practical aspect that if a complaint is made many years ago, then there may not be the witnesses available for the defence that would have been available had the matter been brought to the court immediately. So there is that counter-argument to say the delay has lost an opportunity for the best evidence to be available for consideration by the jury in those circumstances. All right, I won't take that matter any further. Are there any questions? Do you want to make any comments, questions? All good? All fine? Okay. Well, we'll move on. If you do have any questions, let me know. Recent invention is something that you'll see referred to from time to time, and you'll see this in the context of the both the state legislation and the federal legislation. And just as a refresher, of course, the state legislation that I'm talking about is the Evidence Act 1977, and the federal legislation is the Evidence Act 1995, which is part of the Uniform Evidence Laws. So have a look at section 101 of the State Evidence Act. Section 108 of the Commonwealth legislation is similar. And this deals with recent invention. And section 101 of the State Act allows a witness to refer to a previous consistent statement during re-examination if a specific allegation of recent invention was put to the witness during cross-examination. So, you know, at the start I said, look, we don't care that you said this 3 times or 100 times to people at the pub or at the school or whatever. Generally, we don't care. There are some exceptions. One is this preliminary complaint. The other exception is if in the witness box it's put to the witness, you're just making this up now, this is a recent invention by you, then in re-examination, the witness is entitled to give evidence to rebut the suggestion that they've just made it up. Then we do want to know that they made this statement to people at the pub or to a guidance officer or to somebody else in the past, because it's being used to rebut the suggestion that the contrary position is true. So I hope I've made that clear enough. So tonight we've been talking about what is essentially the admission of hearsay evidence, which is what someone, the witness, said previously. The exceptions are if it's a preliminary complaint issue by a complainant in a sexual offence matter, or it's evidence to rebut a suggestion of a recent invention of the evidence. Okay. But you would have read about that in your material. The other thing is often you'll see a witness in examination in chief, particularly a police witness, ask for permission of the court to refer to contemporaneous notes. Now, what is all that about? Can the witness refer to notes that they've prepared when they're giving evidence in the witness box? Can they generally do that? Take in their script, take in their statement?
Isn't it that if they want to do that, the whole statement then becomes admissible as evidence, not just the sections that they're refreshing on, using as refreshing?
Yes.
To refresh.
Yes. So there's some rules that relate to that. But just generally from first principles, I think the general rule is this. If you're going to give evidence in the witness box, then you can't take your notes in with you. There is an exception, And that is if the notes were prepared by you, or at least under your direct supervision, if you like, at the time that the event occurred, and the court permits you to refresh your memory by referring to that document, then that's okay. But there are some conditions that need to be met. The first is the witness needs to refresh their memory, and there's a good reason why they should be provided the opportunity to refresh their memory by referring to their notes. And they need the court's permission to do that. So when you watch a police officer go into the witness box, you will often hear them ask permission to refer to their notes for the purposes of accuracy, in terms of providing the evidence, and that's the reason they offer as to why they should be able to refresh their memory by referring to their notes. But those notes have to be prepared by the person themselves, or at least verified by accuracy, and it has to be done at the time. So we talk about them being contemporaneous notes, contemporaneous with the events that are described in those notes. So they're the conditions about someone taking some notes into the witness box with them. It's pretty strictly applied. But if those conditions are satisfied and the court is satisfied to allow them consent, then they can refresh their memory from those notes. But bear in mind, it's not the document itself that becomes the evidence. It's still the evidence that's being given orally by the witness that is important in those circumstances. Now, I think, Jessica, you mentioned the rules that relate to the extent to which those documents can become part of the material. Have a look at Walker against Walker. It's 1937, 57 CLR at 30. And that case deals with the ability of a party to insist on the entire document going into evidence as evidence of the truth of the content if the first party calls for production of that document from the second party. So in some circumstances, that will apply. So if you are counsel for party A, let's say, and you call for production of a document by party B, then party B can insist on the entire document going into evidence, and that then becomes evidence of the truth of the contents. So you've got to be careful about the rule in Walker and Walker. In criminal law, that's probably irrelevant because the Crown have an obligation to produce all documents anyway. So it's not really going to be an issue, but it still can be. All right, well, thank you. In your reading, you would no doubt have been aware of the requirement to read carefully certain sections of the Evidence Act. So you really need to understand the Evidence Act well for the examination and for the assessment pieces. So have a look at sections 17, which deals with hostile witnesses, 18 and 19 of the State Act. What do I mean by a hostile witness? Anyone give me an idea of that? No? Okay, so a hostile witness, I tell you what a hostile witness is not. Hostile witness is not somebody who's grumpy or angry, not necessarily anyway, or argumentative or aggressive. That's not what we mean by a hostile witness. A hostile witness is someone who is called to give evidence, who, when giving that evidence, gives evidence which is entirely contrary to the evidence that the person who called them expected them to give. So we expect, the Crown prosecutor says, I'm going to call Bloggs, and Bloggs will tell you that this occurred at this time in these circumstances. Crown prosecutor says, I now call Bloggs to the stand. Bloggs goes into the stand Now, what do you recall of these events? And instead of saying what the prosecutor expects, they say something completely and fundamentally different about important issues that go to the heart of the matter. In those circumstances, the prosecutor is entitled to ask for a direction of the court, an order of the court, directing them to be a hostile witness. And Jacqueline's right, there is a witness who is not giving the evidence as discussed. In those circumstances, the person who called the witness will be entitled to cross-examine that witness in relation to what they've said. In the Crown, in the federal jurisdiction, we call them unfavourable witnesses. Have a look at section 38 in that regard. Okay, so that's really all I want to talk about in terms of examination in chief, unless you've got any other questions. So let's talk about cross-examination, the second phase of oral examination. So why do we cross-examine? What's the purpose of cross-examination? I'll get you talking eventually. No one? All right.
Raise doubts in the mind of the jurors.
Raise doubts, absolutely. And in a criminal law matter, all you need to establish is a reasonable doubt. So, yes, when you're cross-examining, you want to raise doubt. You want to reduce or weaken the credibility of the evidence that's given in the examination in chief. But you want to do that, and you want to be careful to do that in relation to things that are material. When I say material, I'm really talking about important things. You know, so often I've had clients that approach me, they read the witness statements prepared by prosecution and disclosed, and they don't really talk about the important things. They talk about some of the collateral things. And they say, oh no, it wasn't 1997 when we went on that holiday to Rockhampton. It was late 1996. Therefore, she's lying about this allegation. She's got her dates all mixed up. That proves that it didn't happen. Well, that's not really going to help. Sure, it might be incorrect, and we might be able to prove it was incorrect. But does that prove that the allegations are untrue? I don't think so. And when it comes to third-party witnesses, not complainants, but third-party witnesses, you know, an eyewitness says something like, and I saw the defendant driving a motor vehicle at excessive speeds, running red lights, going through stop signs, and weaving in and out of traffic. What colour car did you see? It was a red car. Other evidence suggests it was a green car. Aha! Well, that means all this evidence about a red car is out. It's wrong, it's incorrect, it's got no value. Really, that's not the way it works. We expect people to have different versions of events, and sometimes the detail is different. But that doesn't mean that the evidence is of no value and shouldn't be taken into account. So just be careful about the way in which you cross-examine. Try to cross-examine on material things, important things. There are limits on how you cross-examine. You can't bully people, you can't harass them, and you can't ask improper questions. So have a look at section 21 of the Act, the Queensland Act in that regard. So when you're considering what is an improper question, then you have to think about the person that you're asking questions of. And the court is entitled to make a ruling as to whether it's a proper or improper question when they consider the mental, intellectual, or physical impairment that the witness has or appears to have. And they'll also take into account things like the age, level of understanding, the education, the cultural background of the person giving the evidence. They'll also take into account any relationship that that person may have with the defendant or the other side. If you're looking at the issue of improper questioning, also have a look at Section 41 of the Commonwealth Act, which gives the court power to disallow certain questions, particularly if they're questions that are misleading or confusing, or annoying or harassing or intimidating. And a very common one is if the question is repetitive. So if you're in a courtroom situation and you sense that your opponent is not getting from the witness the answer that they want, be on guard to object on the basis that questioning from that point onwards may become improper. Because as your opponent becomes a little frustrated, I'm not getting what I want from this witness, they may lapse into error. They may start to bully or annoy or harass the witness. They may try to humiliate the witness, or they'll be becoming repetitive. Or they might use a tone that is belittling or insulting. So just be aware of that and be ready to object. And cite Section 41 if you're in the Commonwealth jurisdiction, or 21 if you're in the state jurisdiction. I'll just digress for a moment. You do know what I'm talking about when we say we rely on the state jurisdiction, or the state legislation or the Commonwealth legislation. You know the circumstances when that will apply. Depends on the nature of the case. And also, largely it depends on the court you're in. So if you're in one of the federal courts or the family court or the federal circuit court, then you expect that you'll be looking at the Commonwealth legislation, the Uniform Evidence Act. If you're in the state courts, the magistrates, the district, the Supreme, you'll probably be looking at the State Evidence Act. But it depends on what type of matter you're dealing with. If you're dealing with a Commonwealth matter in the magistrates court, then of course the uniform or the Commonwealth legislation applies. Have a look at an interesting case of RV Soma. It's 2003 212 CLR at 299. That was a case where Soma was convicted of rape following a trial. And the Crown decided not to include a statement that Soma had given to investigating officers. You see, when it comes to presenting the evidence, the prosecutor has a wide discretion. And very often, if a person goes into the police station and gives a formal statement and says, I didn't do it, and then quite often the police just won't play that. They won't present that as part of their evidence because they say, well, that's self-serving and we're not going to present that as part of our evidence. But sometimes, if prosecution choose not to do that, they can actually come unstuck. And Soma is an instance of that. So the Crown didn't lead the statement of Soma, which he gave to the investigating officers. So what did Soma do? He gave evidence. And he gave evidence contrary to what he'd said to the police. Counsel then played the statement that they didn't initially play, and they said that that proved that Soma had made a previous statement which was inconsistent to what he was saying in the witness box. But what that really meant was that the Crown was presenting part of its evidence in its evidence in chief, and in its case. When Soma was giving evidence, that's the defence case. So it's not permissible. The High Court said it's not permissible for the Crown to introduce new evidence at this stage, because what they're really doing by that is splitting their case. And they said, look, the basic principle is that the Crown has to present all its case fully and fairly before the jury before the accused goes in to give evidence, if they choose to give evidence. There is an exception to that. There's always an exception to that. Have a look at Shaw against the Crown. It's an earlier decision. It's 1953 85 CLR at 365. in Shaw, the High Court said that the prosecution, the Crown, may be allowed a right of reply to evidence led by defence if that evidence could not reasonably have been anticipated by the Crown. So that's the exception to what I was describing in Soma. All right, I won't go for much longer tonight, but there is a very important, really important principle that I really want you to understand. And this is the rule in Brown and Dunn. Okay, has everyone come across the rule in Brown and Dunn? Give me the thumbs up if you know it. If you're ready to answer a question on it, good on you, Diana. All right. So just to recap, Brown and Dunn is this. It basically says that counsel take instructions from their client and they use that material when they're cross-examining the other side's witnesses. Counsel has to put to those witnesses for the Crown the information that they've got that they intend to lead in evidence later. And the reason for that is that the Crown witness needs an opportunity to explain themselves or to comment on the evidence that is going to come later. So in those circumstances where there has been a breach of the rule in Brown and Dunn, it is possible to recall witnesses in those circumstances. Look, I mentioned the bench books. Have a look at bench book 32. And what it says in the context of Brown and Dunn is this. In preparation for a trial, usually counsel will be given his client's instructions, that is, what his client has to say about the matter in written form taken by a solicitor or in oral form by what the client says when they met, or both. Counsel then uses that information from his client to ask questions of the opposing side witnesses. However, communication between individuals is seldom perfect. Misunderstandings do occur. The solicitor or barrister may miss something of what their client is telling them. And in the pressure of a trial, counsel may simply forget to put questions on an important matter. So this is the judge talking to the jury. You should consider whether there are reasonable explanations for the failure to ask the complainant if there is a failure, and you should not draw any inference adverse to the defendant's credibility unless there is no other reasonable explanation for the failure. Okay, so the rule in Brown and Dunn is you've got to put these things to the Crown witnesses. You've got to put these suggestions so they can counter them, so they can comment upon them. But if, as counsel for the defence, you forget to do that or there's some reason for it, it can be explained away and the judge will ask the jury to be reasonable in considering that there may have been some other reason for the failure to comply with the rule in Brown and Dunn. But I would ask you, in the context of any examination question that you may face, to consider the rule in Brown and Dunn and be ready to talk about the consequences for failing to comply with that rule. Well, I mentioned before about the evidence that may be given in circumstances where it's not dramatically important to the case. We might regard it as collateral to the case. In those circumstances, just be aware that there is a rule, we call it Finality Rule, in relation to collateral issues. So a collateral issue is one that relates solely to the witness's credit. It's not relevant to the fact in issue. And the general rule is that the first answer given by a witness to a question that deals directly or solely with credit is the final answer. There's a case of R against Livingston, 1987, 1 Queensland Report 38. The court talks about why we have that rule, and it's basically so we don't go on forever arguing about a collateral issue, which is not that significant. So if someone gives evidence in cross-examination to say it was this date and it's not really relevant to the circumstance, or it was this colour car, then we can't have the Crown come in and bring other evidences to contradict that. It's collateral to the issue. It's not directly relevant to the issue. That's in general terms that I'm talking. Okay, so when we're talking about cross-examination as to credit, we're really talking about trying to attack the general credit of the witness as opposed to attacking what the witness directly says about the evidence that they are giving from their own five senses. And there are limits as to cross-examination as to credit. Have a look at Section 20 of the State Act and Section 106 of the Commonwealth Act. So Section 20 of the Act, locally, the Evidence Act Queensland, says the court may disallow a question as to credit put to a witness in cross-examination if the court considers an admission would not materially impair confidence or in the reliability of the witness's evidence. And there's similar provisions in the Commonwealth legislation. Right, well, the final part of oral evidence is re-examination. And the important thing about re-examination, which is where the Crown witnesses, the Crown Counsel is able to deal with the witness, is that the re-examination must only relate to issues that arose out of cross-examination. So it's not a chance to have another go and emphasise all the good points that the prosecution witness gave during examination in chief. We don't want to hear the whole story again. That's not what re-examination is all about. Re-examination is dealing with very discrete, particular issues that arose during cross-examination. Again, there are limits on that. So have a look at Section 39 of the Commonwealth Act, where it's laid out that the witness can only be questioned about matters arising from cross-examination, and other questions may not be put unless the court gives leave. While I'm on that point of the Commonwealth legislation, also have a look at Section 46, which deals with leave to recall a witness, and that deals with the breach of the rule in Brown and Dunn. Okay, bear in mind that some witnesses are what we call special witnesses, and have a look at Section 21A of the Evidence Act. This is a really important provision of the Act, which deals with a special witness being entitled to give evidence in a less intimidating way than an average witness. Children under 16, or someone with a mental or intellectual or physical impairment, might be regarded as a disadvantaged witness, and also someone who might suffer emotional trauma or be intimidated and disadvantaged through the process of cross-examination might be a special witness. So it's really important that you have a look at Section 21A of the Evidence Act in Queensland. Have a look at the way in which the law deals with affected children. Section 21AD of the Act is important in that regard. It outlines the circumstances of what's meant by a child and the circumstances about when the matters are relevant for the giving of evidence via videotape recording. So Section 21AK of the Act is really important because it outlines the circumstances when an affected child's witness evidence is given by videotape recording. We call it a pre-record. The 21AKs, typically you'll hear that around the district court, it's pre-record. And it means that the videotaped recording of the evidence is then presented to the court at the trial, but it's not given live. Now, the process works this way, that the evidence is presented via remote conferencing. By I mean, when I say remote conferencing, I don't necessarily mean that the person who's giving the evidence is, 100 kilometres away. They may be closer than that, but they're not in the courtroom. And so the affected child typically is in a different room, in a different location perhaps, but certainly in a different room to the courtroom, and presents via a video. And the people in the courtroom, typically the judge, judge's associate, prosecution and defence counsel, and the client, the defendant. I'm saying it from my defence hat perspective. And the Crown will run the evidence of the affected child through in the normal manner, albeit via video, and defence counsel will cross-examine in the normal manner, albeit by video. All of that's recorded, and then on day one of trial, the jury's impanelled, and typically prosecution will now play that pre-recorded evidence for the jury to consider. So that's the way it tends to work. So have a look at that in conjunction with section 93A of the Act as well. Okay, so a few tips for the exam from tonight. Brown and Dunn and 21AK 93A. Okay, any questions? You've been very patient with me tonight while I prattle. All good? If you, good luck with your first assessment piece. I'm sure that you'll all have a good time with it, and don't take it too seriously. Okay. All right. Well, thank you very much for attending. There's no talk next week. Next week, I'm practically fully booked up with Zoom sessions. What I expect I'll do is I'll probably just have one Zoom link, and I'll let everybody know to dial in at their time. And when you dial in, we're pretty much straight into it. So it'll be straight into examination in chief and then cross-examination. Okay. All right. All the best. I'll end the recording now. Bye for now.